Hi, I'm Louisa Sijabat, a liquidator and bankruptcy trustee. Today's question is, I'm the shareholder of a company that's now deregistered. I wasn't a director of this company. I think the directors might have taken money out of the company, perhaps improperly, before it was deregistered. Is it worth me getting the company reinstated and a liquidator appointed so that the directors can get investigated? So the answer to this question, in my opinion, is that it depends. Now, I should say I'm not a lawyer, so I'll give my answer from the point of view of a liquidation and what a liquidator would do if such a company were reinstated and a liquidator appointed. So if a company is reinstated, I believe this has to be through the courts. So there are legal costs involved in doing that part to get it reinstated and to get a liquidator appointed. Once a liquidator like myself is in there, we'll have a look at the financial transactions of the company in the lead up to its liquidation, or in this case in the lead up to its original deregistration. Now, when we look at money taken out by the directors of a company, we look to see, amongst other things, if the amount taken out was reasonable or unreasonable. So, for example, we'll look on a total basis. So just say the director might have taken a salary or director's fees or wages or something like that of, say, $60,000 a year. But they may have had the company pay their personal expenses of, say, $20,000 a year. Now, is $80,000 as a package for that director reasonable or unreasonable given the size of the company, the director's responsibilities, and what it would cost if there was a third party, like unrelated person in there doing that director's role, like a manager of the company or the business or something like that. Now, in this case, it may look unfair or feel unfair to the shareholder to be seeing the director paying very personal type of expenses, like expenses that would never have been expenses of a company or expenses of the business, through the business's bank account. But as a liquidator, when we look at it, we have to look at it as a total set of benefits that the company, that the director received from the company. Now, if that's reasonable or falls within the realms of what could be reasonable, there may not be any claim against that director, or if there is, there may not be a claim that's commercially worth pursuing or commercially justified to pursue, which means this shareholder, I guess former shareholder, has potentially spent this money to get the company reinstated, pay for a liquidator to go in there and have a look in some circumstances, and there may be no recovery, which means they've now thrown good money after bad. And so it may not be commercial in that particular situation or worth that person's time, energy and money to do so. Now, it does very much depend on quantity, because if it's alleged or suspected that the director took out hundreds of thousands or millions of dollars, then at that stage it might be commercial for a liquidator to go have a look, then any potential claim might actually be worth pursuing. So it does very much come down to an economic equation of, is it worth the time, cost and money for this shareholder to do so, and what's a worthwhile use of that person's money now for them and the next steps and any potential recoveries.